A federal judge has just done something that Donald Trump ES Inner Circle desperately hoped would never happen. After months of stalling, deflecting, and hiding behind legal technicalities, the court has finally drawn a hard line. And now, Trump DS top advisors are scrambling behind closed doors. Not for political messaging, not for damage control, but for survival. Because this time, the judge isn't asking nicely. She's demanding documents, real documents, internal communications, financial records, and detailed explanations for every single piece of evidence Trump's team has tried to keep hidden. For years, Trump's legal strategy has followed a familiar pattern: delay everything, deny responsibility, and hope the clock runs out before accountability catches up. It worked in business, it worked in politics, and until now, it's worked in court. But this ruling changes everything. A federal judge overseeing the January 6th case has ordered Trump legal team to stop hiding behind vague claims of privilege and produce a full inventory of what they withholding within days. No blanket excuses, no general claims. Every document must be identified, justified, and defended. And that's where the panic begins. Because buried inside those documents could be evidence of what Trump and his advisors actually knew, when they knew it, and how far they were willing to go to stop the truth from coming out. Text messages, strategy memos, emails that were never meant to see daylight. This isn't just another legal setback. This is a moment where delay tactics collide with judicial authority, and the consequences could ripple far beyond one courtroom. So what exactly did the judge order? Why is Trump's inner circle suddenly lawyering up? And what happens if these documents are finally forced into the open? Let's break it down. To understand why this ruling sent shockwaves through Trump's inner circle, you have to understand who is making the call and what kind of courtroom this is. The January 6th federal case isn't some symbolic inquiry or political theater. It's a criminal prosecution operating under strict federal rules, where evidence matters, deadlines matter, and excuses eventually stop working. And at the center of it sits a federal judge who has made one thing very clear from the beginning: delay tactics will not be rewarded. From the earliest hearings, the court showed patience. Trump's lawyers asked for more time, then more time again. They argued that the volume of documents was massive, that privilege issues were complex, that national security, executive authority, and constitutional rights were all somehow at risk. At first, the court listened, but as weeks turned into months, a pattern became impossible to ignore. Trump's legal team wasn't just slow, they were selective. They produced what helped them. They withheld what didn't. And when pressed, they leaned heavily on sweeping claims of privilege without offering specifics. That's a red flag in any federal case, because discovery isn't optional. In criminal court, discovery is the process that forces both sides to exchange relevant evidence. You don't get to decide unilaterally what the other side is allowed to see. You don't get to bury documents just because they're inconvenient. And you certainly don't get unlimited time to review materials while the clock quietly runs down. That's exactly what prosecutors began arguing was happening here. They showed the court that Trump's team had been granted multiple extensions, more than is typical in cases like this. They demonstrated that requests for additional time were becoming repetitive and vague. And most damaging of all, they began presenting evidence that contradicted the defense's privilege claims. In some cases, prosecutors already had copies of communications Trump's team insisted were protected. They got them from witnesses, from third parties, from overlapping investigations. And when those documents were compared side by side, the story unraveled fast. Messages labeled privileged had been shared with political advisors who weren't lawyers. Strategy memos claimed as legal advice were clearly about campaign messaging and public pressure tactics. Some communications didn't even involve attorneys at all. At that point, the issue stopped being about complexity. It became about credibility. Federal judges expect precision. If you claim privilege, you must explain exactly why. who wrote the document, who received it, when it was created, and which legal protection applies. Broad catch-all excuses don't survive scrutiny. That's when the court's tone shifted. What had once been flexibility became firmness. The judge made it clear that the defense had exhausted the court's patience, and that the case would not be allowed to drift indefinitely toward the election calendar. And then came the order, a direct command requiring Trump's team to produce a detailed privilege log, item by item, within days. No more delays, no more general claims, and no more hiding behind procedural fog. In federal court, that kind of order isn't routine. It's a warning, and Trump's advisors knew exactly what it meant. Because once a judge decides you're playing games with the process, every future move gets scrutinized, and every mistake carries consequences. At first glance, the judge's order might sound procedural, even boring, a demand for paperwork, a deadline, a legal formality. But inside a federal criminal case, this kind of order is anything but routine. Because the court didn't just tell Trump's legal team to turn over documents. It demanded something far more dangerous, a full itemized privilege log. And that changes everything. A privilege log isn't a summary, it's a confession without commentary. For every single document Trump's team is trying to withhold, they now have to list the date it was created, who wrote it, every person who received it, what it's about, and the exact legal reason they claim it's protected. No vague explanations, no blanket claims, no hiding behind general phrases like confidential or executive communication. Each document must stand on its own. And here's the problem. Once you describe a document in enough detail to justify privilege, you often expose exactly why it isn't privileged. That's the trap. If a memo discusses political strategy instead of legal advice, privilege fails. If a message includes non-lawyers, privilege fails. If communications touch on potential illegal activity, privilege can fail entirely under well-established legal exceptions. That's why this order is a nightmare. Trump's team isn't just risking disclosure, they're risking losing privilege altogether. Federal judges have the authority to rule that if privilege claims are improperly asserted or poorly documented, those protections are waived. That means documents the defense desperately wants to keep hidden could be forced into evidence immediately. And there's more. The order comes with a hard deadline, just days to comply. That's aggressive by federal court standards, especially in a case involving thousands of documents. It signals the judge's belief that further delay is unjustified and unacceptable. Miss the deadline, and the consequences escalate fast. Contempt of court is not symbolic. Judges can impose financial penalties, strike motions, limit defense arguments, or even order full document production as a sanction. In extreme cases, individuals can face personal liability. That's why advisors are panicking, because the people most exposed by these documents aren't to just the defendant, they are to the people around him. Political strategists, outside advisors, operatives who thought their communications would never be scrutinized line by line in open court. Now they're facing an impossible choice: turn over documents that could show knowledge of wrongdoing, or refuse, and risk sanctions that could strip away every remaining legal protection. There's no third option. What makes this worse is that prosecutors already know what they're looking for. They've hinted that they believe privilege claims were used not to protect legal advice, but to hide evidence. And once a judge accepts that framing, the defense loses the benefit of the doubt. This order doesn't just force compliance, it changes the power dynamic. From this point forward, every claim made by Trump's team is viewed through the lens of skepticism. Every delay request is suspect. Every assertion of privilege must be proven, not assumed. That's why this moment matters. It's not about paperwork. It's about whether a defense strategy built on delay and obscurity can survive judicial scrutiny. And for the advisors caught in the middle, the walls are closing in. Once the judge forced Trump's legal team to itemize what they're hiding, the conversation stopped being theoretical. Because now the question isn't T if documents exist, it S what as inside them. And that's where things get dangerous. Prosecutors have made it clear that they refocused on a specific window of time, the weeks between the 2020 election and January 6th. That period isn't random. It's when Trump was publicly claiming the election was stolen while privately being told something very different. The documents at risk include internal communications between Trump and his advisors, text messages, emails, and memos discussing election fraud claims, pressure campaigns on state officials, and planning surrounding the January 6th rally. If those communications show advisors telling Trump that the fraud claims were false, exaggerated, or unsupported, and Trump continued pushing them anyway, that directly undercuts one of his core defenses, lack of intent. Intent is everything in criminal cases. Then there are strategy documents. Some of the materials prosecutors are seeking reportedly involve planning conversations that blur the line between legal advice and political coordination. That distinction matters. Courts protect legal strategy. They do not protect political plotting wrapped in legal language. If memos discuss how to influence public opinion, pressure lawmakers, or create alternate slates of electors, those aren't privileged legal communications. They're evidence. And those documents don't just implicate Trump. They implicate the people who wrote them, forwarded them, and acted on them. That's why advisors are suddenly nervous. Some of these individuals assumed they were operating in Trump-S orbit, not that they to become central figures in a federal criminal case. But once documents are disclosed, prosecutors don't just look at the content, they look at patterns. Who coordinated with whom? Who was present at key moments? Who knew what and when? There is also the issue of financial records. Funding trails matter. If documents reveal who paid for transportation, security, or organizational support connected to January 6th activities, that opens a completely different legal front. Financial evidence can corroborate intent, planning, and coordination in ways testimony alone can't. And perhaps most concerning for Trump's inner circle is the possibility that some communications involve discussions of actions that may cross legal lines. Attorney-client privilege does not protect conversations about committing or covering up crimes. That's a fundamental principle of U.S. law. If prosecutors convince the court that certain communications fall under that exception, those documents don't just get disclosed, they become powerful evidence. This is why the pressure isn't evenly distributed. Trump himself has a legal team and a public platform. Many of his advisors don't. They face personal exposure, separate from Trump's political fortunes. A text message that once seemed routine could now be interpreted as participation in a conspiracy. That fear is already causing fractures. Reports indicate that some advisors are quietly consulting their own attorneys, not Trump's lawyers, but personal counsel. That's a critical moment in any case. When potential co-defendants start lawyering up individually, unity collapses. And once unity collapses, the prosecution gains leverage because cooperation becomes tempting. Silence becomes risky, and loyalty starts competing with self-preservation. All of this flows from one court order, a demand for transparency that threatens to turn private communications into public evidence. The kind of evidence that doesn't just hurt a legal defense, it reshapes the entire case. The moment the judge's order landed, the legal battle stopped being abstract. Inside Trump's inner circle, the reaction wasn't defiance, it was fear. Because everyone understood what this order really meant. The protective wall around their private communications was cracking. And it might not stop there. For months, Trump's advisors had operated under the assumption that privilege claims would shield them. That even if prosecutors pushed, the process would drag on long enough to keep damaging material buried. That assumption is now gone. And when legal certainty disappears, self-preservation takes over. Almost immediately, cracks began to form inside the team. Some advisors pushed for full resistance, appeal everything, fight the order, accuse the judge of bias, and turn the disclosure fight into a political spectacle. From their perspective, compliance equals surrender. Others weren't so sure. Because, unlike Trump, many of the people around him, Don T., have a movement or a fundraising machine to protect them. They don't have a political base willing to absorb legal fallout on their behalf. They're private citizens who could face real criminal exposure. That difference matters. Reports began circulating that some advisors were quietly seeking independent legal counsel, separate from Trump's defense team. That's a major warning sign in any criminal case. When potential co-defendants stop relying on a single unified strategy, trust erodes fast. Suddenly, conversations change. People start wondering who might cooperate, who might flip, who might protect themselves if prosecutors come knocking. Every past message gets re-examined through a new lens. A casual text, a forwarded email, a meeting note that once felt harmless. Now, each one carries potential consequences. And the pressure is relentless. The judge's deadline leaves little room for internal coordination. Trump's lawyers have days, not weeks, to sort through mountains of material. That means advisors are being contacted, questioned, and forced to clarify their involvement in events they hoped were behind them. Some are pushing back, others are panicking, because the risk isn't evenly shared. Those closest to January 6th, planning, the people involved in messaging, logistics, and coordination, face the highest exposure. They know prosecutors are building timelines, connecting dots, and looking for evidence that shows intent and coordination. And they also know something else. Prosecutors already have pieces of the puzzle, testimony from witnesses, documents obtained from other sources, public statements that don't align with private communications. All of that means the defense doesn't control the narrative anymore. That's when loyalty becomes fragile. Trump's legal strategy has always depended on unified resistance. Delay together, deny together, attack together. But that strategy only works when everyone believes the wall will hold. This order suggests it won't. And when people start believing that the wall is coming down, their incentives change. Cooperation with prosecutors, once unthinkable, starts to look like a way out. Silence starts to feel dangerous, and internal finger-pointing becomes inevitable. This isn't just a legal problem, it's a human one. Fear makes people unpredictable, deadlines make them desperate, and the threat of personal liability makes them rational in ways loyalty never could. That is why this order has destabilized Trump as inner circle more than almost any ruling before it. Because it forces a choice no one wanted to make. Stand together and risk everything, or protect yourself, and let the chips fall where they may. For years, Donald Trump has treated the legal system like a battlefield of endurance. The strategy was simple: never resolve anything quickly, challenge every subpoena, appeal every ruling, demand extensions, argue privilege, and if all else fails, attack the judge and question the legitimacy of the process itself. It worked until it didn't. This disclosure order represents the moment where that playbook finally collides with a judge who refuses to play along. In Trump's world, time has always been the most valuable asset. Delays push trials closer to elections. Elections reshape political realities, and political power can, in turn, reshape legal outcomes. Running out the clock wasn't just a tactic, it was the plan. But that plan depends on cooperation from the court, and that cooperation has now ended. By imposing a short, non-negotiable deadline and demanding precision instead of generalities, the judge has effectively shut down the delay machine. There's no room here for endless motions or vague privilege arguments. The defense must act immediately or face consequences. That's a fundamental shift. In previous cases, Trump's team could rely on procedural complexity to slow everything down. Judges often prefer caution. They grant extensions to avoid claims of unfairness. They allow extra time to prevent appellate issues. But this judge has clearly decided that fairness no longer requires patience. From the court's perspective, Trump's team has already had more than enough time. Multiple extensions, multiple warnings, multiple chances to comply. What looked like caution early on now looks like obstruction, and federal judges do not tolerate obstruction. What makes this moment especially damaging is that the judge's order does not just affect this case. It creates a record, a paper trail showing that Trump's team, not prosecutors, caused delays. That matters because Trump's public defense has always relied on claiming victimhood, that he's being rushed, that due process is being denied, that the system is unfair. This order undercuts all of that. Every time Trump claims the prosecution is moving too fast, prosecutors can point to the court record and say the opposite. Every time he claims he wasn't given enough time, the judge's ruling says otherwise. The delay narrative collapses, and without delay, the defense is exposed. The trial schedule moves forward, evidence gets locked in, motions get decided. And suddenly, Trump is facing the possibility of a trial that actually happens, on the court's timeline, not his. That's a nightmare scenario for a defense built on waiting. Worse still, the collapse of the delay strategy puts pressure on every other tactic. Privilege claims become riskier, appeals become harder. Aggressive rhetoric becomes less effective when the court has already documented bad faith behavior. Judges talk to each other, prosecutors learn from each other, and once one court signals it won't tolerate games, others may follow. This is how legal momentum shifts, not with one dramatic verdict, but with a series of rulings that tighten the window for maneuvering until there is nowhere left to go. Trump's team is now reacting instead of controlling the pace. They're answering deadlines instead of setting them, and that's a position they're not used to being in. Because once the courts stop letting you run out the clock, you're forced to confront the evidence. And the evidence is exactly what Trump's strategy was designed to avoid. At this stage, Trump's team isn't deciding whether to comply. They're deciding how painful non-compliance will be. Because in federal court, ignoring a direct order from a judge is not a delay tactic. It's a provocation, and the consequences escalate quickly. The first and most immediate risk is contempt of court. That's not a symbolic warning. If Trump's lawyers miss the deadline, submit an incomplete privilege log, or continue making vague claims, the judge has wide discretion to impose sanctions. Those can include heavy fines, restrictions on future filings, or rulings that strip the defense of procedural protections it normally relies on. But that's just the beginning. One of the most dangerous consequences for the defense is waiver of privilege. If the court determines that privilege claims were asserted improperly or in bad faith, it can rule that those protections are forfeited entirely. That means documents Trump's team fought to hide for months could be turned over immediately without further argument. In other words, the punishment for abusing privilege can be losing it, and that outcome would be catastrophic. Because once those documents enter the record, prosecutors don't just read them. They build timelines. They cross-reference testimony. They identify inconsistencies. And they decide who else might face exposure. There's also the risk of individual liability. While Trump is the defendant, lawyers and advisors are not immune from consequences. Courts can refer matters for disciplinary review. Judges can sanction attorneys personally. And if evidence suggests intentional obstruction, that opens an entirely new legal front. This is why the pressure is so intense behind the scenes. Trump's team can attempt to appeal the order, but appeals take time, and the deadline doesn't automatically pause enforcement. Judges don't look kindly on last-minute appeals designed solely to stall compliance, especially after a pattern of delay. They can also try partial compliance, producing a privilege log that technically exists but lacks detail. That's a dangerous gamble. Judges recognize half measures, and they often respond by tightening the screws even further. Then, there's the nuclear option, outright defiance. Some of Trump's most hardline allies believe this is the only acceptable path. Refuse to comply, accuse the court of bias, turn the legal fight into a political spectacle, dare the judge to impose sanctions. But that strategy assumes something risky, that the court will blink. Federal judges rarely do. Once a judge decides a party is acting in bad faith, every subsequent decision becomes less forgiving. Extensions disappear, arguments get less traction, and penalties escalate. The real danger is that defiance doesn't just hurt Trump, it traps everyone around him. Advisors who didn't control the legal strategy could still suffer the fallout. Lawyers could face professional consequences. And once sanctions start stacking up, internal blame becomes unavoidable. Who advised this approach? Who pushed for defiance? Who ignored warnings? That kind of internal reckoning is poison for a defense. Because while Trump may benefit politically from confrontation, others don't. They're forced to weigh loyalty against their own futures, and the longer non-compliance drags on, the more attractive cooperation becomes for anyone seeking an exit. That's the pressure point prosecutors understand. Courts don't need to threaten jail to change behavior. They just need to make defiance more painful than compliance. And that's exactly what this order does. It forces Trump's team to choose between immediate damage and long-term disaster, with no option that preserves the status quo. This court order doesn't just affect one case, one defendant, or one election cycle. It reshapes the terrain Trump has relied on for years. Legally, the most immediate consequence is momentum. Once a judge signals that delay tactics won't be tolerated, the entire case accelerates, deadlines tighten, arguments narrow, and the defense loses the ability to slow the process through procedural fog. That matters because Trump's strategy across multiple cases has depended on time. Push trials past elections, push decisions past moments of political vulnerability, let public attention drift, let momentum die. This order disrupts all of that. If documents are disclosed, even partially, prosecutors gain leverage not just in this case, but potentially in others. Evidence uncovered here can inform charging decisions elsewhere. Witnesses identified through disclosed communications can become cooperating sources. Patterns established in one courtroom can ripple outward. That's how complex prosecutions evolve. Politically, the impact is just as significant. Trump's core supporters may interpret any legal action as persecution. But courts don't operate on slogans. They operate on records, and records matter to everyone else. Moderate voters, independents, and institutional actors tend to view firm judicial enforcement differently. To them, a judge insisting on transparency doesn't look like bias. It looks like the system functioning. That distinction is crucial. Because Trump's public narrative depends on portraying himself as a victim of unfair process, this order undermines that framing by documenting repeated extensions, opportunities to comply, and a clear pattern of delay. Once evidence enters the public record, rhetoric becomes harder to sustain. If communications show that Trump was told his fraud claims were false and continued pushing them anyway, that erodes trust far beyond his base. If documents reveal detailed planning around January 6th, the political cost could be severe. And then there's the precedent. Former presidents have always occupied a gray zone when it comes to accountability. This order pushes that boundary. It reinforces the principle that no one, not even a former president, gets special treatment in criminal discovery. That's not just symbolic. It sends a message to future administrations, to political operatives. To anyone who assumes power comes with immunity. Courts retain authority, rules apply, and privilege is not a magic shield. History shows moments like this matter. Legal experts often point to past cases: Watergate, corporate fraud scandals, national security prosecutions, where judges eventually stepped in to stop delay and force transparency. Those interventions didn't just affect the cases at hand. They reshaped expectations about accountability. This order has that potential, and it doesn't exist in isolation. Other judges handling Trump-related cases are watching. Prosecutors in other jurisdictions are watching. They're seeing that strict deadlines and firm enforcement can work, and that courts don't have to indulge endless procedural games. That creates a chilling effect for defenses built on obstruction. For Trump personally, the long-term risk is that legal reality begins to intrude on political ambition. Campaigning becomes harder when court dates advance. Messaging becomes riskier when evidence looms. And allies become cautious when association carries legal exposure. This is how power erodes, not in one dramatic moment, but through cumulative pressure. And it all stems from a single decision, a judge choosing to stop the clock. Everything now funnels toward a single, unavoidable moment, not a verdict, not a dramatic courtroom showdown, but a decision made quietly, behind closed doors, under extreme pressure. Trump's legal team has days, not weeks, to decide how this ends. Do they comply fully, knowing that transparency could expose damaging evidence? Do they comply selectively, hoping the judge accepts their claims and spares the most sensitive material? Or do they resist, gamble on escalation, and dare the court to impose consequences? Each path carries risk. None offers safety. That's what makes this moment so consequential. Because for the first time, Trump's defense isn't operating on its own timeline. The court is in control, and when courts control the pace, strategy gives way to reality. If the documents are produced and reviewed, prosecutors will gain clarity they've been chasing for years. They'll see who said what, who warned whom, and who kept going anyway. They'll be able to connect intent to action, planning to execution. If the documents aren't produced or are produced inadequately, the consequences may be even worse. Sanctions, adverse rulings, forced disclosures, a judge who no longer gives the defense the benefit of the doubt. Either way, the outcome changes the case. And that as the deeper question hovering over this entire moment, what happens when delay finally stops working? For Trump, delay has always been more than a tactic. It's been a shield, a way to avoid finality, a way to keep multiple outcomes alive at once. As long as nothing resolves, everything remains possible. This order threatens that equilibrium. It compresses time, it narrows options, and it forces accountability into the present instead of some distant future. For Trump's advisors, the stakes are even more personal. They're not running for office, they don't control the narrative, and they don't benefit from prolonged chaos. Every document disclosed carries potential consequences that don't disappear with a news cycle. That's why fear has replaced bravado inside the inner circle. Because once evidence enters the record, loyalty doesn't erase liability, silence doesn't guarantee safety, and delay no longer offers cover. The next few days will tell us more than months of rhetoric ever could. Not because of what Trump says publicly, but because of what his team does privately, what they choose to turn over, what they fight to keep hidden, and how the court responds. Those decisions will shape not just this case, but the broader question it represents. Can the legal system force transparency from someone who's spent a lifetime avoiding it? Can procedural rules withstand political pressure? And does accountability still function when power resists it at every step? The answers won't come in a press conference. They'll come in filings, in deadlines met or missed, in documents that finally see the light of day. And once that happens, there's no putting the story back in the shadows. Before we close, it is important to be clear about what this story is and what it is. This case is still unfolding. No verdict has been reached. No final ruling has been issued on the documents themselves, and under the law, every defendant is presumed innocent until proven guilty in a court of law. What we're watching right now is not a conclusion. It's a process, a federal court enforcing rules that apply to every criminal case, a judge demanding compliance with discovery obligations, and a legal team facing the consequences of how it chose to respond. None of this determines guilt on its own, but it does determine something else: whether transparency will be forced where delay once prevailed. That distinction matters because the strength of a legal system isn't measured only by convictions. It's measured by whether procedures are followed consistently, especially when powerful figures are involved, especially when political pressure is intense, and especially when the outcome could reshape public trust. This story isn't about politics versus law. It's about whether law can function when politics tries to overwhelm it. Over the next several days, filings will be made. Deadlines will either be met or missed. Judges will respond, and documents may finally move from private files into the public record. When that happens, the narrative will change, not because of commentary, but because of evidence. Until then, everything remains in motion. We'll continue following what actually happens in court, not speculation, not spin, and not talking points. Because in moments like this, facts matter more than volume, and process matters more than outrage. If new developments emerge, we'll break them down clearly, carefully, and without hype. Because the real story isn't how loud the reactions are. It's whether the rules hold, and whether accountability, when tested, still works. If you want to stay informed as this case continues to develop, and as the documents at the center of this fight potentially come into the open, make sure you are subscribed. This story isn't over. It's just reached the point where the clock can't be ignored anymore.